Welcome to Tax Sale Insiders, the latest from Tax Sale Resources, bringing you information about tax sales from experts in the industry. We brought back William Hereford, a partner at Burr & Foreman based in Birmingham, Alabama. Will was pushed into tax lien law in the late 90s, figuring out what to do with those unredeemed lien portfolios, and he hasn't looked back since. In this, his second interview, William shares the ins and outs of how to invest in the state-owned DOR properties. If you are interested in the over-the-counter investment process, stick around for a potential opportunity. Sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
Hi, everybody. Welcome back. I guess I was lucky enough to get Will Hereford with us again. For those of you that didn't attend his first webinar or interview, Will's an amazing attorney, met through the NTLA. He specializes down in Alabama, and he's located there in Birmingham. But he and I talked a little bit on the last interview about I'd say problem or opportunity, depends on what side of the fence you're on, but all of the parcels that end up being state owned in Alabama. And so I was able to coax them back to kind of help describe that a little bit more. But anyhow, Will, welcome back. Thank you for joining us again.
Thank you, Brian. I enjoyed our last talk too, so I'm looking forward to this one.
All right. Well, I guess we won't dive too much into, if you want Will's full history of how he got into the space, what he does on the normal tax sale side, definitely check out our other interview. I won't dive into that again here. So let's focus on the Alabama Department of Revenue parcels. And I guess the main thing is, so Will wrote a great law review article. I don't know if you folks can see it out there. We'll send a link to go download that here shortly. It does an excellent job kind of describing the situation and what you can do to kind of capitalize on it from an opportunity standpoint. But really, what stuck out to me, Will, was really the first paragraph, basically stating, in 2005 there were just under 8,600 state-owned parcels. And that number jumped up to over 38,000 state-owned parcels in 2017. So I'd say that it's definitely a problem, trending in the wrong direction. So I guess, can you give us a little background of kind of like how did we get there? How do parcels end up being state-owned, and why are there so many, I guess, in your opinion?
Sure. So what we're talking about are properties that are sold for auction at the county level auctions, and they end up being owned by the state of Alabama, excuse me, and managed by the Alabama Department of Revenue. Sorry, Brian, I got to look through my throat.
No worries.
So under Alabama's tax sale system, every year counties put these properties that are tax delinquent up for auction. And the minimum bid for those properties is the amount of taxes and interest due. And if a property does not get that minimum bid, it's deemed to be sold to the state of Alabama. So it's as if the state of Alabama were there bidding and it's the winning bidder. And that property then goes on a list of delinquent properties owned by the state of Alabama. Let me clarify. So that's been the historic tax sale tax recovery method for Alabama throughout the years, where the property was sold and it was sold at an auction to the highest bidder. There's a new system in Alabama right now that we talked about the last time we talked, and it's a lien sale. It's not selling of the land, and it's not a bid up auction. It's a bid down interest rate auction. And so under that new system, there are no sold estate properties under the new system. So I think There are 33 counties out of, I think, 67 counties in Alabama who are using that new system this year. So you have about half the counties in Alabama using the tax lien bid down interest system, and then about half using the old land sale bid up auction. These tax delinquent properties that we're talking about with the state come out of the old land sale bid up auction process. All right, so for the properties that are listed for sale at these, if they don't get the minimum bid, they're sold to the state and they join that state list. Those properties on the state list can be redeemed, they can be bought from the state, but the rate of properties going on to the state's inventory every year has exceeded the redemptions and the purchases from the states by a significant amount. And that's why the number that the state holds has grown. So just to sort of recap what you said earlier, Brian, in 2005, the number of state-owned properties, state-owned tax delinquent properties, is 8,595. That number jumped to 25,000 by 2012, and then by 2017, it had jumped to 38,664. So what that means is over that period of time from 2005 to 2017, you had, there were 38,000 more properties that were being added onto the state's list than were coming off the list during that time. So each year, it may increase by several thousand. I don't know what the exact number is, but several new thousand properties come on the list. Maybe 1,000 or so will come off the list, but the net difference is that there are more properties being added to that sold to state tax delinquent list. And 38,000 is not an insignificant number. I mean, that's a huge number of properties, as you can imagine, and represented in 2012. That represented like $141 million worth of tax revenue lost by the state, because when these properties go to the state properties are not taxed, so there's no tax being collected from those properties. So it's a loss of revenue for the state every time one of those properties goes to the state.
But a couple questions on that. So you mentioned the result of these or the state-owned properties is a result of the old system, or that system's still in use, but it's the system, the tax deed system, right? With roughly half the counties going to the new system, I guess theoretically that should mean fewer properties going on to the state-owned list on a yearly basis, right? I mean, I guess.
Yeah, I think that's a safe assumption.
But what happens to them now, I guess, or is that still yet to be seen, of the liens, right, that don't get sold? I mean, what's making people want to buy the lien more than the deed before? I guess maybe you don't have answers to it. These are pretty theoretical questions. Well, I don't mean to put you into a corner, so we don't know. Certainly no problem. But are they actually selling more liens that way, or are they just not being bid, and instead of going to the state, the county has to hold that lien?
You've identified it. So okay. On the new, let me just clarify a couple of things. So yes, since half the counties are not using the old land sale system, the deed sale system, there are now going to be fewer properties going to the state, because that's the method that results in the state-owned tax delinquent properties. In those counties that are using the lien sale system, let's just say you had the same proportion of properties are not getting sold at that lien sale as you did at the old land sale deed system. Well, under the new system, the properties that are not sold go to the county to deal with, and then they conduct their own sale later. I don't know what the accumulation of those properties is going to be. I would say one thing is that I think the counties are more equipped to deal with those than the state is to deal with the state delinquent. So let's say like Shelby County, one of the counties that went to the new lien sale system, if say 40% of their properties did not sell, then Shelby County remains in control of those properties, and they can sell them later under certain procedures. and perhaps they're more motivated to do that dealing with their own property in their own county than the state would be. So, but the kind of a point is, I think you're maybe underlying what you're saying is there are going to still be unsold properties under the new tax sale system.
Right.
But today, I think we ought to focus on the ones that the state owns, because that's what I wrote about, and that's where it's the problem really exists right now, and where the opportunity possibly exists as well.
Okay, and that's where, I guess, from an opportunity standpoint, that the opportunity doesn't necessarily go away. You just have to go to a different entity to talk to it. You might, instead of going to the state, right, and the Department of Revenue, you're gonna have to talk to the individual counties. But the main thing is that the problem isn't necessarily solved by the new tax sale system. It just puts the onus on the county as opposed to the state to deal with that problem.
Yes, and so like the example, Shelby County was one of the first counties to move to the new system. Well, any properties that were from Shelby County that had been sold under the old system to the state of Alabama, they're still there with the state of Alabama. So it's still an issue for those counties that have moved to the new system until, as long as these older properties from the older sale still with the state, there's still an issue there, still a problem for those counties. But presumably, if all counties move to the new system, then you would cut off the flow of properties to the state, so the state number would not increase.
Right. Okay. So theoretically, over time, that large number of state-owned parcels should come down in theory, right? But the county-owned parcels should go up, and so for folks to out there looking at this as an opportunity, you may have to change where you're looking in 5 years from where you're at today, but it doesn't mean that there are no opportunities. So the process that we're going to talk about more today is just the state-owned Department of Revenue parcels, and how you go about buying those is going to be different than how you go about buying those county-owned parcels. So maybe let's start with that. How does one go about purchasing one of these from the state?
So the process would be you go to the Alabama Department of Revenue website, and if you typed in tax delinquent properties for sale search Alabama, it'll probably take you right to the link, and you can search on there. But let's say you've identified a property and you think it's on the state list, then you'll have the parcel number or the owner or something. You'll have something to plug into the search, do the search. And once you pull up the property that you're interested in, there's an application that you fill in that you send that you email to the Department of Revenue, or I guess it may be actual just a electronic send. And so you're asking for a price quote is what you're doing, and the state will respond with a quote. It's been a typical thing, particularly for more desirable properties, that there would be a lot of applications ahead of yours if you were to put an application in, and whoever is first in line, once they get a quote back from the state on a property, then they have 20 days to respond, to send the money in and accept the quote. And if they don't, then it goes to the next in line, working its way down. And so some, I've heard them say that there could be 15 or 20 people in line.
Okay.
So what's happened, for whatever reason, people have learned about this. They feel like there's a great opportunity here, and they'll just blanket applications to the state for purchasing properties, and then the ones they get back, they'll pick the ones they really want. So what that ends up doing, it ends up burdening the Department of Revenue, dealing with all these applications that end up not buying them, and all that delay that in time. So it's not a great effective system from the state standpoint in terms of efficiency and getting rid of these properties, because they go through a lot of applications that never end up buying properties.
Right. Is there
the quote?
Okay, go for it. I think you're going to answer my question.
The quote amount that you'll get will be basically the past due taxes and interest on the property. So it's like a redemption amount that you'll pay.
That's exactly what was my question, is how does the state come up with that asking price? Is it arbitrary and they just go find out and say, hey, I want X dollars, but it sounds like it's based on whatever the delinquent taxes are plus interest, right?
Right.
Okay.
Right.
Okay. Is there any difference for, because I know Alabama has a different process compared to a lot of states with like a first 3-year period and a second 3-year period. Is there any difference in what you're getting from the state depending on how delinquent it is?
Yes. If you apply within the first 3 years following the tax sale and you receive a quote from the state and you pay it, you'll basically get an assignment, which is an effect from the state, which is effectively a certificate interest in the property, not a deed interest, not a title interest. And so it's as if at that point you're getting a tax certificate, which then you can apply to get a deed for when the 3 years from the tax sale expires. If you submit your application after the 3 years from the tax sale and you get the quote from the state and you send your money in and get the property, you'll get a tax deed from the state. Okay. And then which represents legal title, but still subject to redemption rights under Alabama law.
Okay. So I'll focus on the ones that are 3 years or older, where you actually get a deed to the property. What does that title look like? Is it insurable?
No, it's not insurable. I don't expect anybody necessarily would go back and watch the other interview we did about Alabama law, but once you get that deed from the state, you're back in the situation of someone who had bought it originally at the tax sale, received a certificate, and then later got a deed. And that deed, according to Alabama law, is a legal title to the property, but still subject to redemption rights and still subject to being challenged.
Okay.
So now we're
like buying
in the category. Okay.
Sorry, go ahead.
Well, once you get that deed, now you're in the situation is, okay, what do I do to clear title or to provide for an insurable title to the property? You're in the same boat that you would be in, like I said, if you bought the property originally at the tax sale.
Okay. So your options at that point, and correct me where I'm wrong here, you can go through a quiet title and I can't remember the name of the other process, or I guess the process that you kind of pioneered, really, we call ejectment, right? Which is a quiet title plus, what was that other process?
Yeah, well, okay. I didn't develop any of these causes of action. These are long-standing causes of action, but the claims I will make would be an ejectment claim, which is a claim for possession of the property based on the tax deed, which you're entitled to possession as the owner of the property. Quiet title is sort of a mirror image of an ejectment action. Ejectment action is I have legal title to the property, but someone else claims to be in possession or is in possession, and I want to remove them, I want to eject them from the property. Quiet title requires possession, and what you're claiming is I have possession, I have title to the property, but others are claiming title also, and I want the court to determine that my title is superior and that my title eliminates the other people's title to the property. And then the other thing I bring when I bring a cause of action or bring a lawsuit is a declaratory judgment. I don't know if that's what you were talking about or not, but basically asking the court to confirm that the sale and transfer of deed into the current owner is all valid. It's all been handled correctly. Okay. So that the title is good, to go ahead and eliminate any question about the original tax sale, the state sale to the tax deed holder, just to clear all that up at the same time.
So your options after you buy that deed from the state are to wait the additional 3 years. Once you get possession, then you file a quiet title, or you could file an ejectment, which has the I guess the possession piece and the quiet title piece kind of baked into one. You don't have to wait that 3 years to go through the quiet title. Do I understand that correctly?
Well, that's a good question. And that's the question you're raising, which I'll restate but that was the reason I wrote my law review article. Let me get into a little bit of background about that. It may help explain my answer to your question about this 3-year issue. So with the number of properties with the state increasing, that creates a lot of issues, a lot of loss of tax revenue. The state, I don't think, believes this, but I think the state should have some concerns that they may have some responsibility for these properties because they're legally the owner of the properties. And I don't, being responsible for almost 40,000 properties is a pretty big deal that I think the state has just figured we don't have any liability, but I don't know. And some legislators picked up on the growing number and introduced bills a few years ago that would require the state to sell all the properties that it owns that are more than 3 years old, which of the, say, 38,000, I don't know how many of those are more than 3 years old, but let's say it's half of them. So half of 38 is 19,000. Well, the idea of the bill, the proposed bill, and this legislator is good. It's like, we don't need to have these properties on the state doesn't need to be on these properties. We need to sell these and put them back on the tax rolls. But the idea of selling 19,000 properties would probably end up being a disaster. There's no market for 19,000 properties all at one time, the way the state would have to sell them. But the point was, to me was, but something needs to happen. Forcing the Department of Revenue to sell them all at once is probably a disaster about to happen, but something needs to happen. And I was pointing out in the law review article that one of the reasons that the rate of purchase is not greater than it is, why more of these properties are not bought, is because of uncertainty by purchasers in terms of what they would have to do to clear title to the property. They don't want to buy the property from the state and be left in a limbo as what their interests are, what their rights are. There's a strong belief out there in Alabama that you have to be in adverse possession of property that's been purchased from a tax sale for 3 years to be able to clear title to the property. So that means if, let's say, you bought a deed from the state, you have to go in possession of it for 3 years and then bring your quiet title action. And anytime during that time period, and then at the time you bring your lawsuit, redemption could be, the former owner could raise the issue of redemption and possibly end up being able to redeem it. And so one of the factors that some of my clients have told me that why they haven't gone and made more of an effort to buy property from the state is they don't want to have to wait 3 years after getting a deed to find out whether they're going to get clear title or not. And so the purpose of my article is saying, there are lots of factors here involved, lots of things that need to be considered in order for the state to sell more of these properties. But here's one area that we could clarify that might help things. And let's clarify that you don't have to be in adverse possession for 3 years to clear up the title to the property, that you should be able to do that through this ejectment lawsuit. So that in bringing the ejectment lawsuit, which you could do right after getting the deed, then the owner, if they want to redeem, they have the option to redeem it while that lawsuit is going on. But if they don't redeem it and the judge enters an order establishing the tax deed holder's right to possess the property and confirms the purchaser's title, well, then that's it. That eliminates all rights of redemption, and any challenge to the tax sale is that order entered by the judge granting ejectment, granting possession in favor of the purchaser. And I think the law supports that. It's not clearly stated anywhere. You have to piece together Alabama ejectment law, Alabama quiet title law, and cases that have dealt with tax sales and all. But I think policy supports that position. I think you can piece together a law that firmly supports that position. And so I was saying, let's accept that as being okay, and that way purchasers approaching the state would know they're not going to have to buy it and sit on it for 3 years. And so the conclusion of the article was, I think the law supports that conclusion already, but wouldn't it be helpful if the legislature passed some bill to just affirm that, yes, that is what the law is, to remove any uncertainty? And that would remove uncertainty for title companies, because they would say, okay, it's very clear to us now that this ejectment lawsuit that I think clears up the title can clear up the title. Yes, the legislature said that's right, so the title companies would be more comfortable. And then perhaps that would lead to more properties being sold by the state, title being cleared up, and the properties being put back into use, and more revenue coming back to the counties and state.
Right. Now, so it sounds like, I mean, the ejectment, it doesn't really matter when you purchase that. As long as it's after the 3 years, you get the deed, you can start the ejectment. You don't have to wait 3 years. But for those that are opposed to the ejectment route, is there any advantage of only buying the parcels that are, at least 6 years delinquent, or does that 3-year clock start no matter how delinquent the parcel is?
Yeah, if there is a adverse possession requirement to clear the title to these properties, which many people believe there is, but I happen to think you can run around that or override it through the ejectment lawsuit. But if there is, it's measured from when the owner or the purchaser gets a deed. So if it's been 6 years since the tax sale and they get a deed from the state, if there's an adverse possession requirement, it's going to begin there at that point.
Okay. So it doesn't matter how delinquent the parcel is, it's the 3-year clock starts whenever you purchase that deed from the state.
If there is a 3-year.
Okay.
Right.
Got it. Now, you mentioned some legislature that was being proposed, and I believe in the article, neither one of those pieces of legislature ended up passing, correct?
That's right. The legislature that proposed it, I think, did it 2 years in a row, and it never passed. And it would have, like I said, I appreciate the legislature's recognizing the problem and seeking a solution. Personally, from my experience, I think it would have been a really difficult thing for the Department of Revenue to try to do that, and I think it would have been a lot of paperwork, a lot of hassle, and it would not have been a successful sale the way the bill set it up. But I think the idea behind the legislation was good, is that there's a problem here, and we can't just continue to let these properties accumulate on the state's list like that.
Right. Is there, other than the changes that implemented the new, tax sale process, are there any other changes being proposed in the legislature or coming down the pipeline that would, affect this whole process?
Well, no. I guess 2 years ago, I was on a couple of committees that were working on some changes to the tax sale law that would bring improvements to various areas. And we had the groups consisted of county revenue commissioners, lobbyists, law practitioners like myself, really just a variety of people, everybody that's involved in this whole process. And we came up with some pretty good changes, I thought. One would clarify the law that I was encouraging to be done through my law review article. Other changes dealt with other issues that are sort of little knotty issues that get, come up with redemptions and all the tax sales that everybody realized they don't benefit anybody. And everything was going very smoothly. And then it just got in, somebody at the last minute before the legislative session opened, decided there was something that wasn't right about the legislation and stirred some stuff up, and it just killed it.
Oh.
So it was a real disappointment to all involved, especially to me, because I'd been one of the main people drafting the legislation, and had gotten really everybody involved buying into it, saying, yeah, they thought this was a good idea. There's no downside to it. Because all of it's geared toward making it easier to clear up title to the, if somebody's going to redeem, make it easier for them to redeem. But if they're not going to redeem, making it easier to clear up title to the property, because It doesn't do any good to have a growing list of properties with screwed up titles. It doesn't help anybody.
Right.
And so the proposed legislation was to try to help bring more clarity and allow for more properties to be cleared up, either through redemption or through, in effect, the foreclosure process on a tax deed.
So you're not, there's nobody, and you're not continuing to try to pass something or anything else that's coming down the pipeline?
No, I mean, I wouldn't have anybody else to go to about it, because I thought everybody that needed to be involved was involved there. And it kind of wore me out, frankly.
Yeah. I
spent a year, a good year working on it, meetings and drafting and meeting with different people and explaining it, and thinking it was sailing through, and then to have it disrupted like that was it was a good education for me about how our legislative process works. So I learned something from it, but I wasn't anxious to take it up again.
Understood. There's only so many hours in the day, right?
Yeah.
Well, Will, I guess anything else you want to share or think are key points of the again, for all those that want to go check it out, there'll be a link that we send out here shortly, but Will's law review paper, which describes all of this in much more detail. They're more welcome to go and read that. Anything else out of there that you want to make sure gets highlighted?
Yeah, the nuance of the legal argument I was making in there isn't really, I don't think it's really important for most people who may be looking at this as an investment. It was pretty dense, but the intention was to explain something carefully that would support an effort to bring clarity to this area of law. I think the first 10, 12 pages or so that describe the problem, maybe, if somebody thinks, hey, this is an opportunity, I think they'll understand the problem more if they read that part of the law review article. And so basically the problem is that there's been this growing number of state properties that the state owns that have been taken off the tax rolls, and which means if there's a big problem like that, there's an opportunity. Mm-hmm. And to fix that, or to speed that process up of getting those properties off the state roll, is going to take some sort of solution. And one would be if the state could come up with a new system for selling those. It may require new legislation, or it may require somebody being creative and going to the state and saying, we want to propose something to you, and a method of putting out sets of hundreds of properties at a time for bid versus one at a time. Right. And coming up with some approach that the state would think, okay, that sounds reasonable and we will consider that. And exactly what that would be, I don't really know exactly what it'd be, but I have some ideas. And so that would be one thing to consider. One thing the state is trying to do to reduce those is that there's one land bank in Alabama right now in Birmingham, and there are other communities that want to have land banks. And the way the legislation with the land banks works, the state can kind of push off some of these properties to the land bank and let them deal with it. And so I think the Birmingham land bank has removed, dozens, if not hundreds, of properties from the state list and turned them over to people after declaring the title. So that's helped some. And so some of these properties that people may be interested in may be with the land bank, and you may be able to buy them through the land bank. So that's one place to go look. But I think that that covers it. So the problem is you've got 30,000 plus properties that the state owns that are off the tax rolls, and there needs to be a solution to getting as many of those off the state roll, the title cleared up, and put them back on the tax rolls as possible. One of the big problems is that a lot of these properties, probably the majority of them, have very, very low value. Those are the ones that tend to get sold to the state. Mm-hmm. And then you've got the cost of clearing the title. So sometimes economically you cannot justify buying it from the state and clearing up the title. The property value just won't support it in many situations. So that's a problem there. But if there are 30-something thousand properties, there's got to be hundreds of them at least that do have value that would make it worthwhile to go through that process. Right.
Well, Will, thanks again for joining us and I guess educating me again, educating everybody else on here. I think there's definitely an opportunity there. Hopefully some of you watching go out and Google Alabama Department of Revenue delinquent tax properties and pull it up and start looking at it. So Will, thanks again for joining us. And
you're welcome, Brian. Enjoyed it. Thank you.
All right. Have a great one.
You too. Bye-bye.